This is my video in continuation to my individual spat, my individual reading of various books, admiring those quotes written by various judicial and political leaders of various heads. Now, I was just reading in my earlier video, and which I would continue. I had read what Robert Rauni, a professor of political science, had said. What is becoming clear is that the restructuring of the democratic process has altered the pattern of citizenship, where once the public official, as in the days of cantonment, had a deep and honest sense of public sacrifice. We are today witnessing the close collaboration of special interests with government agencies and elected officials. In the cantonment issue, government too often emerges as the advocate of exploitation. This is in large but due to the subtle private and usual corporate pressure. Pressure has become a science that destroys the government shield the citizens have erected to protect themselves. It is necessary for the government to guard against such pitfalls. The choice is between technological progress, which proceeds with adequate regard of its consequences, and technological changes that is influenced by a deeper concern for the interaction between man's tool and the human environment in which they do their work in these cantonments. What better could say? A mandate of our constitution is to build a welfare society, and legislation made in this behalf to give effective to directive principles of state policies have to be respected. If the constitution obligations are not discharged by due enforcement by the administrative agencies, the court cannot turn a Nelson eye. The fundamental duties are intended to promote people participation in restructuring and building a welfare society. And the directive principles under Part 4 are intended to build the edifice of welfare state. Environment and its preservation is a subject matter of both, thus emphasizing the importance given to it by our constitution. Protection of environment is a matter of constitutional priority. Neglect of it is an invitation to disaster. The problem is the concern of every citizen, and action brought cannot be dismissed on grounds of local standi. What I understand and what I actually understood by reading these books, somewhere it said we have to create an association. We have to bring people like-minded together. We have the same cause of action. So the same cause of action is that we are fighting the Ministry of Defense. Our fight is for ownership of these lands. Now, how it has to be done, achieved, is a matter of grey. That is why in 2009, I created an All India Cantonment Bungalow Owners Association. We created history in 2012 by having a conference in New Delhi. It's been 10 years since now. What has happened? We've disintegrated. Why? Because I was demanding a legal cell. I was demanding a remuneration for any legal advice to be given to a resident of a cantonment on his issues of notices. Notice could be under section 185, notice could be under section 73, those are taxation and building notices. Notice could be of illegal sale, notice could be of mutation, notice or non-denial of an admission deed. So there were so many issues which were culminated. We got together, we dug into the research. Lately I realized when the British officers or the lawmakers had written in the law books, then why is it so that the judiciary was interpreting the entire cantonment old grant terminology as a grant under the crown grant or a government grant? No. Even the Britishers never expected that the GG of 179 1836, which was repealed in 1837, if I'm not wrong, under regulation number 260. Why is it continuing? Why? Because that same GG of 179 has been amended till 1864 in the parallelity when the first Cantonment Act was launched in India, that is 1864. So get up, wake up, yaar. I can only request you with folded hands. Some people say, Mr. Das, why don't you make these videos in Hindi? Honestly speaking, I've many a times tried, let's go to the Google interpreter or do something. Laws are written in English. All these books which I have dug in from 1765 are in English. Apart from, I admitted that I can speak better English. I can understand English more better than Hindi. So I abide. But please, you are residents of these cantonments. You have to understand English. If you can't get into the generation which can understand English, I'm not saying that you are wrong by asking me of getting these videos in Hindi. But I can't. I've tried. It cost. Even getting those subtitles down below, each video will be costing me 1,000 rupees. Have I asked any bungalow owner or any resident to pay me for the last 10 years on any of my expenses to maintain the association, to maintain the website? Nothing comes free. I'm getting these videos made, I'm educating, I'm digging into research. I have a judgment dongle which I annually pay subscription for. So even if I tentatively say there is an yearly expense of mine which goes down the drain, that is about 20 to 30,000 bucks. Friends, please, I'll read a quote again. When the word lose their meaning, what is left with a citizen? Please, I request, behind all the theoretical talk of government and legitimacy behind the system and projects, behind even the forms of government itself, there is a culture, a living organization of mankind upon which all the talk of system and mechanism depends. For both its eligibility and for its effectiveness. It, in all its complexity and interconnectedness, it is our substantive and actual constitution. So wake up. We need to join hands, club ourselves together. Even otherwise, I'll quote something what has been justified in a court, exercising its power of equity in the realm of epistolary jurisdiction under three critical principles of equity, which are: where there is a right, there is a remedy. Equity court is a court of conscience. Third, judges in equity rule, act according to conscience. So, friends, when these things are so clear for the judiciary, why can't our advocates, our luminaries bring forth in front of the judiciary? What is our plight living in these cantonments? Professor Adam Charles of Harvard had said in a book of law, which I was reading, the characteristic feature of the public law model are very different from those of the traditional models. The party structure is sprawling and amorphous and subject to change over the course of litigation. The traditional adversary relationship is suffered and intermixed with negotiations and mediating process at every point. The judge is the dominant figure in organizing and guiding the case, and he draws for support not only on the parties and their counsels, but on a wide range of outsiders masters, experts, and oversight personals. Most important, the trial judge has increasingly become the creator and manager of complex forms of ongoing relief, which have widespread effects on persons not before the court and require the judge's continuing involvement in administration and implementation. So here see what he said, it's the lower court. So the role of a judge in a public law litigation, equity jurisprudence is based on hardship, accident, trust and fraud. This is what it is. So what are we going through? We don't trust the system. We don't trust the policies of the government. We are dealt under a fraud law. So everything is hard for us. The onus is on the authorities concerned to establish by demonstrable evidence and not by undisclosed measures that action has been taken to control and hold basic law with reasonable limits. The fraud evidence alleged by the petitioner consists of both evasion of land records and our rights. Discretion of the quality of this environment is impermissible, as is evident from a series of legislations enacted by the Parliament from time to time in the interest of a clean and honest evidence. In general, as already pointed out, none of the authorities concerned who have been impleaded as respondents in this petition have either denied the existence of these land records but have come forward with an explanation as to what measures have been taken in order to curtail these land records. But every time they make a new record or they make a new law, in these circumstances, there is a sufficient basis to hold that the grievance of the petitioner as to the existence of these land records is affecting its existence in these cantonments to the detriment of the residents of a public is substantiated. I am therefore of the opinion that on that score also the writ petition should be allowed who seeks justice for better living in these cantonments. I am only reading. I am only a communication. Lord Depok has also confirmed the principle when he said, it would, in my view, be a grave lacuna in our system of public law if a pressure group like the federations, associations, or even a single public spirited taxpayer was prevented by outdated technical rules of local standi for bringing the matter to the attention of the court to vindicate the rule of law and get the unlawful conducted stopped. So there are so many things which can be done. But who is doing all this? A man is stranded on an out of the way desert island with neither food nor water. A sailor from passing ship comes ashore but leaves the man to die. This is as serious as violation of his rights as strangling him. It is killing him, plain and simple, indirectly through inaction, but just as surely, perhaps, even more cruel. So we can't be left to die, neither by the court, neither by the judiciary, by the legislative, the three pillars, or neither by the executives. But we are. Why? Because we are not a group. We are not united. So, with no policies for the cantonments being drafted, nothing coming up for the betterment of the environment in these cantonments, which gives me a free mind that yes, I or anybody, there is no discrimination. Neither he can construct his bungalow, neither his bungalow gets mutated, neither he gets permission for sale, neither his bungalow is demolished and mine is compounded by the commander-in-chief. It is happening at rampart. Does the government own up? Come to the court and say for the last 75 years, not a single permission for sale is given. Not a single mutation of a VIP has been done. I know so many journals whose bungalows have been compounded. And I know bungalows whose commander-in-chief has demolished bungalows under the appeals. What is happening here? Please. So, Burger John Jay in his book, Restoring the Earth, also illuminated some instances. And these instances reflect to my slogan which I had given in 2009. A housewife who led to a crusade to clean up the river in Massachusetts. A Pennsylvanian mine inspector who repaired a strip-mined land. A plumber from Cape Cod who transformed a brush-choked dish into a trout stream. What did I say? I said history is made by individuals but cherished by all. Friends, I am trying my hard, best level. Working round the clock 24/7. Sometimes when I get cases, sometimes when bungalow owners talk to me, residents, I feel so perturbed. Single-handedly, I'm reading judgments, I'm extracting judgments, I am fishing out what is the point which we need to plead, what is the witness questioning to be done, how our advocate should work in the court so that our lower courts and our base of the judgment is absolutely lawful. Supreme Court at times says, did you plead in the lower court? And sometimes it says, even if you pleaded, it doesn't make a difference to us. So we have to rattle this system. We have to shake up everybody. The last I would speak, the right to life inherent in Article 21 of the Constitution of India does not fall short of the requirement of qualitative life, which is possible only in an environment of quality and honesty, where on account of government department the quality of air and environment are threatened or affected, the court would not hesitate to use its innovative power within the epistolary jurisdiction to enforce and safeguard the right to life, to promote public interest. Specific guarantees in Article 21, unfolded penbums shaped by emanations from those constitutional assurances which help give them life and substance. In the circumstantial context and factual backdrop, judicial intervention is warranted, exceptionally since the Supreme Court of India has already laid the foundation of juristic activism in unmistakable language of certain and deep concern. So, some people scare me, Rauni ji, you can't speak about a judgment, you can't, counter a judgment on your YouTube. My coming series will be on judgments now. Why those judgments have gone against us. So please, my another request is subscribe. I want every owner, resident who's watching me or is in touch with me, promote one member on the YouTube, one single member, and let that multiplication grow. And then see, we are barely 18 to 20 lakh people living in these 57 cantonments. 29 lakh if to be more numbered. Thank you for watching me and bearing me, but this is my dream. This is what motivated me, and I hope I am able to motivate you. Thank you. Good day.